Morning, everyone. I hope everyone's doing well today.
Good morning, Judge Morrow.
Hi, Ms. Lewis. How are you today?
I'm doing
Good morning,
good,
Judge.
I hear you're assisting.
Yes, I'm
Good
here.
morning.
All right, very good.
Good morning, Judge.
Hey, good morning, Mr. Finley. Hope you're well.
You as well.
Yes, thank you. Let's see. Who do we have in courtroom 2?
Your, we're gonna go with probation,
Okay.
add-on 1.
Morning, Officer Middleton. Hope you're well.
Good morning, Judge. How are you?
Good, thank you. So this is Mr. Howard. Good morning, Mr. Howard. I'm Judge Eric Morrow. This is the probation revocation calendar. We are holding this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
It's fine.
All right, thank you, Mr. Howard. Officer Middleton.
Thank you, Your Honor. Matthew Howard appeared before Fulton County State Court for the charges of simple battery on April 21st, 2021, and was sentenced to 12 months of probation. He was sentenced to complete an anger management evaluation. And he had a court date on October 20th, 2021, where he missed. He has 4 months to 20 days left on probation, but probation is going to recommend that he be released and return to probation.
So it's just the anger management program. Does he owe any fees?
Oh, yes, he owes $240 in probation fees and $54 in the victim compensation fund fee.
Mr. Finley, is this your client?
Yes, it is, Your Honor.
Okay. Whenever you're ready.
All righty. Yes, Judge Morrow. So we are asking for Mr. Howard to be able to return to probation. He says that he did appear in court on October 20th, but was unable to find the correct courtroom. He'd been to the courtroom before, and he said when he got there, there was no one in there. So he wasn't sure if it was recess, but he attended court and he just stated there was no one in there, and he stayed for a little bit and then left. And he did say that if he did not pay any fees, he would make sure to do that. And assured me he would abide by the probation rules if he is allowed to go back on.
What's the problem with the anger management program?
Let's see. Says so I have right here, he says he did plan on attending the anger management. I did bring that up with him. He said he just hadn't done it yet, but did plan to do so. He said he just had not gotten to it yet.
All right. Well, he only has 4 more months, so if he doesn't get around to it, then that's going to be a problem. So I'm going to follow probations, put him back on probation, but he is going to be required. How often does he check in now, Officer Middleton?
He's supposed to,
You went out on me?
I'm sorry, a month.
Once a month? All right, so I want him to start that anger management program at least in the 2 weeks, in the next 2 weeks, provide you proof that he started in the next 2 weeks. And each month for the next 2 months, if he doesn't provide you proof within 2 weeks, you're to bring him back. If he comes back and has not done a significant amount of it in a month, I want you to bring him back, because I want him to get this anger management done, and I want to monitor him to make sure he does it. And if not, we're just going to be right here. So you're going to be right back where you are, Mr. Howard, if you don't start this anger management in the next 2 weeks. You understand me?
Yes, sir.
All right. And there won't be another chance regarding this. If you miss another court date, again, you won't be given the opportunity to get back on probation. All right, are we clear?
Yes.
All right, good luck to you, Mr. Howard.
Thank you, Your Honor.
You sit over here. Next, we got position number 6, Mr. James Daniel.
This is going to be a arraignment and a bond hearing.
That is correct, Your Honor.
Good morning, Mr. Daniel. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Mr. Daniel, you've been charged in case 12 CR 387689 with DUI, drugs less safe, and no license plate and reckless driving. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
Do you, Judge?
How do you plead to these charges, Mr. Daniel? Guilty or not guilty?
Can I speak with the offender?
Okay, Mr. Finley, he wants to speak. I take it with you.
All right, Your Honor. Can we get put in a breakout room if you don't mind?
Okay, that's fine. Who else do we have here today?
You can call 2392. Call 22392.
Can you say that one more time?
Call extension 22392. Come over here.
Hey, I'm trying to beat him to it.
Okay, Mr. Finley, I don't, who else do we have from the PD's office?
Ms. Hogue?
Hello.
Ms. Hogue, what cases I want to make sure that we take one of Ms. Hogue's cases next so that we don't delay court while you're speaking with Mr. Daniel.
All right.
Yes, Your Honor, I have cases 17 through 33, or in essence, most of the cases between 17 and 33.
All right, thank you.
Hey, Ms. Hogue,
Yes.
position 17 and also position 26. They want to know why they're being reset.
Just because we were not able to reach the agreement, so we're just going with the straight jail jury announcement today.
Excuse me. They came with agreement, ma'am. Time served and time suspended. They go to paperwork right outside my
No,
way.
unless something changed with the prosecutor, that is not the offer.
But I'm
Okay, can I just go to a breakout room then?
Okay, all right, come on, let's go.
All right, so,
And,
Mr. Finley?
Yeah, quick question, Mr. Morrow. So when I'm calling from my cell phone, if one of the officers doesn't mind, what number am I calling? I understand.
Hey, Mr. Finley,
Yes,
Mr. Howard's actually talking to him for you. Well, he's
Yes.
supposed to for you, yeah.
got it. Okay.
No, I wasn't gonna speak with him. It was a different client I needed to speak with. So Mr.
Okay, Finley, then call 22392, 22392. Only got one phone now.
No, I
Right, he can go first.
612, it's 612, Mr. Finley.
Okay, so
612,
it's
I know that's what you're asking for, the prefix, it's 612.
right. So it's 404-612-2392.
That is correct.
Okay. Thank you, sir.
And when he's done, I can speak with Mr. Jackson if he's in the courtroom.
All right, good morning, Mr. Howard.
Good morning, Judge. How are you? Sorry to barge in.
Howard Jackson is upstairs. He's not in this courtroom.
Okay, all right.
All right, so,
We're gonna go to position number 20, Mr. Dwight Matthews. Yes, ma'am.
all right, do we have any public defenders that are with us?
Before I say anything, I just wanted to keep.
Your Honor, that's a conflict attorney case with Terrell Dark.
Mr. Dawson.
I don't see Mr. Dark on the line.
Lord have mercy.
All right, so is Ms. Hogan speaking with somebody?
Not yet, Your Honor.
Okay, so let's hold on. Let's do some of your cases, and while one of you is in talking with someone, we can move the calendar on. Is that agreeable?
That's agreeable, Your Honor. I have probably 3 cases upon which I will be doing bond requests on, and then a 4th one, which I do need to speak to the client a few minutes beforehand, so.
Okay, all right. So what are the numbers that you're going to do bond hearings on?
Okay, number 22.
The others?
Number 29 and number 30.
30. And who are you gonna need to have a breakout room for?
That would be Miss Skipper Diamond, number 27.
27. Okay, thank you.
That's South Annex.
Say it again?
That's gonna be South Annex.
Okay, all right. Mr. Finley, are you back with us?
Yes, Judge Morrow, we are ready.
Okay, all right. So let's complete Mr. Daniel. What's the announcement? We were in the middle of the arraignment.
Not guilty, Your Honor.
All
Plead
right.
not guilty, Your Honor.
Thank you, Mr. Daniel. We will record your not guilty plea. Your case will be returned to the division judge, and you will receive notice of your next hearing date. Let's see, I have that the current bond is 1,000 for the DUI less safe. 1,000 for the reckless and 50 for the license. Is that right?
That is correct, Your Honor.
Okay. Mr. Howard. I'm sorry. Not that, Mr. Howard. Pretrial, Mr. Howard. Are you with us? Oh, Miss Nash. Hi, how are you?
Good morning, how are you?
I'm fine. I saw Mr. Howard in court with me, so I just assumed that it was him. Good morning. Is there a history for Mr. Daniel?
Yes, the defendant has 23 cycles. The defendant's last arrest was January the 23rd, 2022, with the Bremen Police Department, and that was in Georgia. There was no disposition for that arrest. The defendant does appear to be on probation in Douglas County for 2 counts of the violation of the Georgia Controlled Substance Act. That disposition date was November the 8th, 2017, and the term is for 10 years. The defendant does have prior felony convictions, one in 2018 out of Carroll County for possession of methamphetamine with the intent to distribute, and one in 2006 for possession of controlled substance with the intent to distribute. And the defendant does have misdemeanor convictions, one in 2017 for theft by shoplifting, one in 2016 for a DUI, and one in 2012 for a DUI. Nothing in addition, Your Honor.
Okay, thank you. Mr. Finley?
Yes, Judge Morrow. Judge Morrow, as we can see, this case is from 2012, so it is nearly 10 years old. When Mr. Daniel did not hear anything from his lawyers regarding this case, he assumed it had been resolved. And as we heard, he had been in jail previously. And when he was getting in and out of jail in other jurisdictions, this case was never brought to his attention. So he did think that this case was over. Just like Mr. Daniel did in 2012, he is adamantly disputing these charges, Judge. This was a lifetime ago. And as we heard, he does have criminal history, last being in 2018. As of 2019, he's been working to get back on his feet. He graduated from the Sober Living of America, and he's been working on staying clean since that, since 2019. And although his most recent arrest, it is exactly that, an arrest. And for those reasons, Your Honor, we are asking for a signature bond in this case, but if not inclined, then a surety bond not exceeding $500.
All right, thank you. Good morning, Ms. Arnold.
Good morning, Your Honor. How are you?
I'm good, thank you.
I apologize. I didn't hear we were back on this case. Yes, Your Honor. So here in this incident, it did happen on July 23rd, 2011 at the 1700 Howell Mill Road Northwest in Atlanta. Upon arrival, the responding officer noticed the defendant in a green Honda Accord with the engine running. The officer asked if the defendant had anything containing alcohol within the last few hours, and he replied no. The officer noticed that his eyes were glossy and his speech was slurred. The officer then asked if he could do a field sobriety test, and the defendant replied yes. During that test, the officer noticed there was involuntary jerking of the defendant's eyes. The defendant was not able to touch his heel to toe the entire test, and his arms were not always by his side during that test. During the one leg stand, the defendant was unable to maintain balance for more than 4 seconds on several attempts. The defendant advised that he had taken a few prescriptions earlier, and officers noted that there were several prescriptions in his possession at that time. They were all in his name. And at that point, the defendant was arrested. Your Honor, we do believe that the defendant will reoffend. He has a criminal trespass conviction from 2003, probation violation from 2003, theft by shoplifting conviction from 2005, another probation violation from 2006. In 2011, he had an arrest for DUI drugs. 2012, a DUI alcohol conviction. A 2014 probation violation. 2014 arrest for habitual violator of probationary driver's license. A 2015 DUI for alcohol conviction. He also has a 2017 theft by shoplifting conviction, a 2018 possession of methamphetamine with intent to distribute conviction, and then an arrest from January 22 of this year for theft by shoplifting, giving false name, address, or birthday out of the Bremen Police Department. Your Honor, we do believe the defendant is a flight risk as well, due to the fact that he has a 2004 failure to appear, he has a 2012 failure to appear, a 2016 and a 2017 failure to appear. Your Honor, the reason this case is so old is because the defendant also had an FTA on this case. And it was so old that it was at some point administratively closed with the warrant pending. And he was just rearrested for these charges, Your Honor. So we would ask that the bond, and I do apologize because it was so old. It was hard to view an odyssey, but from what I could see, it looked like there was a $3,000 surety bond set for the DUI drugs less safe. And I didn't see actual bonds for count 2 for the no license plate and count 3 for the reckless driving. So we would just ask that that bond remain the same, Your Honor, because we do believe based on his history that he is a flight risk, and we would like to proceed with prosecuting this case.
This is a 10-year-old case, Ms. Arnold. What's the offer on this?
So the offer was 12 months to serve 15 days with the balance probated with credit for time served 8 days, a $300 fine, 40 hours community service, the DUI risk reduction course, no drugs, alcohol, or weapons, no driving unless to work, school, attorney, or medical, alcohol, drug evaluation and treatment, and victims of the VIP.
I'm sorry, what were the last 2 conditions?
Yes, it was the alcohol, drug evaluation and treatment, and then the victims program.
Is that what you normally offer for a first-time DUI?
Your Honor, it's my understanding that we offered that. You're talking about the victims? Are you talking about the last condition, Your Honor? Or are you talking about just in general?
Just in general.
Yes, Your Honor. So it looks like from when I looked at the history, Your Honor, we did not get all of the history until late last night. Originally, we did not have that history, but when I saw it here, he does have a conviction for DUI from 2012 and from 2015.
So those would be after this, though. I have the offense date down here as June 2011. So this would have been his first alleged DUI, right?
Yes, Your Honor. And according to the, so I'm sorry, when I looked at the OCGA, this was for a first offense. I do apologize, Your Honor.
Okay.
So it's according to the code.
All right. Mr. Finley, anything further? He does realize that he can go non-negotiated.
Yes, Your Honor. I just want to point out, as we heard from Ms. Arnold, about 5 of those charges that she did talk about were about 2005 and earlier. So about 17, 16 years and longer earlier. He did assure me that that he would be staying with his mom once he gets out. And I really stressed to him, obviously, to respect the legal process. And he assured me that he would plan on returning to court, Your Honor.
All right, so he's not going to get another opportunity. You know, as I said, he has the opportunity to go non-negotiated today, given the how old this case is. The court would take that into account. If he does not want to do that, then I am going to modify the bond, and you can prepare the same bond that he previously had, but make it a signature bond through the jail. If that's the case, Mr. Daniel, if you don't show up again, that bond's going to be revoked and you're going to be right back where you are. So those are his options for today, Mr. Finley. So.
Okay, Your Honor.
All right, so I take it you want the bond modification?
Yes, Your Honor.
All right. If you'll get me that paperwork, I'll get it signed. Good luck to you, Mr. Daniel. You've been given an opportunity, so make sure that you take advantage of it.
Your Honor.
Yes.
Thank you, Your
Could you
Honor.
see what the signature bond amount is?
It's going to be 1,000 for the reckless, 1,000 for the DUI, and 50 for the no license plate.
Okay, thank you, Your Honor.
You're welcome. Good luck, Mr. Daniel.
All right, thank you, Your Honor.
Your Honor, I apologize for interrupting. Is that a signature bond or is that a straight bond?
That's going to be a signature bond through the jail.
Through the jail? Okay, thank you.
You're welcome.
And Judge, can you say one more time what the amount was for the no license plate?
$50.
$50. Okay. Got it. Thank you, Judge.
Okay. Because that's what the original bond was, so I'm going with that. All right, who do we have, courtroom 2?
We have Mr. Thorman, position number 30.
This is going to be an arraignment and a bond hearing, is that correct?
That is correct, Your Honor. Oh, hold on. I'm sorry, my thing was muted. That is correct, Your Honor. This is Ms. Hogue.
Okay. Good morning, Mr. Thorman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning.
Good morning. Mr. Thorman, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hands up. Mr. Thorman, you've been charged in case 22 CR 0003880H with DUI, driving under the influence of alcohol less safe. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Hogue?
Yes, I do, Your Honor.
Mr. Thorman, how do you plead, guilty or not guilty? It's my understanding that you were going to plead not guilty to this charge today, Mr. Thorman.
Okay, not guilty.
Okay, and I'm just saying what my understanding was. You have to actually tell me that you're pleading not guilty. Is that how you're pleading?
Can I talk to Ms. Hogue?
Of course you can.
Off screen first.
All right, so I guess Ms. Hogue, you're going to have to call the jail if you have the number. And
Is it the
Same number, same number.
Same number. Okay, I'll give a call right now, Your Honor.
All right.
We're gonna go to position number 8, Mr. Antonio Dunn.
It's also an arraignment, is that correct? Mr. Finley?
That is, let me see, check here 1 second. That is correct, Your Honor.
All right. Good morning, Mr. Dunn. I'm Judge Eric Morrow. This is the state all-purpose calendar we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, good morning, Your Honor. I agree.
Okay, thank you. Can you raise your right hand for me?
Hello?
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Mr. Dunn, you've been charged in case 21 CR 002388G with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Dunn? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see, the bond, it's a $10,000 SOB through pretrial. What happened with that, Mr. Finley?
It looks like there was a bond surrender on that, Judge.
And why is that?
See here, so it looks like he was, pull it up here. Looks like he was rearrested, Your Honor. Let me pull that up.
You know what he was
Your Honor, so
rearrested
that
for?
is,
What was he rearrested for?
it was battery, family violence, and false imprisonment.
Okay, and he got a bond on, I guess he went to the.
Yes, Your Honor. So that, yeah, so that one was, that offense date was on 1/23, January 23rd, and he was given a bond on that one.
Okay, what was that bond?
That one was 15,000 surety.
Okay. Go ahead, Mr. Finley.
Alrighty, yes, Your Honor. Mr. Dunn is 39 years old, Judge Morrow. As we've heard, and we just spoke about, he does have a recent arrest history, but he is presumed innocent in that case. Judge, Atlanta is Mr. Dunn's home base. This is where his family lives, his mother lives, who he's extremely close with. His mom has already said that once he gets out, he will be able to live with her. So his ties to the community are strong. From what I've seen, I did not see any FTAs that Mr. Dunn has had. So he's shown that he does have respect for the legal process and will show up to court. And as we know, Judge Morrow, bond is not meant to be punitive, but rather to ensure his return to court. So factoring in his case that he was recently arrested for, he is presumed innocent. And it seems that he will return to court. So that's why we are asking for a surety bond not exceeding $2,000.
Ms. Arnold?
Yes, Your Honor. This incident happened on May 16th, 2021 at 6885 Peachtree, Dunwoody Road, apartment 205. Miss Yesenia Naranjo, first name spelled Yesenia, last name spelled Naranjo, advised that she and the defendant were in an argument about her infidelity. The responding officer noted that both parties smelled of alcohol. He also noticed a large red and raised welt on Miss Naranjo's bottom lip and asked her what happened, to which she initially replied that she had fallen down in her bedroom, which the officer may note is carpeted. So the officer asked again, as her lips seemed to be swelling as they were speaking. Ms. Naranjo stated that that the defendant had pushed her to the floor and stomped her on her face purposely. Officers spoke with their roommate as well, Brian Hutcherson, who stated that he heard a loud commotion coming from the defendant in Ms. Naranjo's room. as well as items possibly being thrown around the apartment. And the defendant was then placed under arrest. Your Honor, we do believe that the defendant will reoffend. As you know, he was rearrested on 12322 for the battery, family violence, and false imprisonment, which is case number 22CP206083. And he was ordered with this bond, Your Honor, that there be no further contact with the victim, Ms. Yasina Naranjo. And that battery case that is open from the first of this, from January 23rd, is with the same victim, Your Honor. So we do believe that he will reoffend, Your Honor. So we would ask that the bond remain at that $10,000 surety bond.
All right. I didn't set this bond, but when I do set a signature bond through pre-trial, I put the amount to be commensurate with what I think that it should be. Apparently, they thought it should be a $10,000. If he violated the bond, $10,000, given that he violated it allegedly with the same victim, he was given a no further violent contact with the victim at that time. I'm going to leave the bond where it is. Good luck to you, sir. All right, who do we have next?
Position number 14, Mr. Hargrove.
This is also a not guilty arraignment and a bond hearing. Ms. Finley.
That is correct, Your Honor.
All right. Okay, thank you. And I'm being told, Mr. Finley, that Mr. Hargrove is not being held on these charges. So. Good morning, Mr. Hargrove.
Oh, yeah. So I apologize. Then could we just do an arraignment actually on this one, Your Honor? Thank you.
Good morning, Mr. Hargrove. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Hargrove, you've been charged in case 22 CR 000359B with 10 counts of cruelty to animals. Well, 1, 2, 3, 4, 5, 6, 7 counts of cruelty to animal, 1 count of obstruction, 1 count of dog at large, and 1 count of tethering. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you put your hand down. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
Yes, Judge.
How do you plead to these charges, Mr. Hargrove? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
All right, we're gonna go to position number 30, Mr. Thorman.
All right, are we ready, Ms. Ho?
Yes, we are.
All right,
Yes,
so
we are, Your Honor.
All right, so my last question, Mr. Thorman, was how do you plead to this charge of driving under the influence less safe, guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What's the current bond?
Your Honor, the current bond is a $6,000 surety bond, which we'd like to be heard on.
Okay, do you have that bond? Go ahead, Ms. Hogue.
Yes, Your Honor. Mr. Thorman is 36 years old and he is a Georgia native. He's lived here all of his life. He has a high school degree as well as a technical degree. He's worked in IT for over 10, 12 years. He does have a history of DUIs, Your Honor. He has a stable address. He has a job. He has everything that would require him, that he has no indication that he would be a flight risk, Your Honor, no indication he would not come back to court. So we do believe a $6,000 surety bond in this case is not warranted. Obviously, we always like signature bonds, but we do believe 2,000 would be more than ample for him to be able to show up to court and take care of this matter. I read the report. According to the report, as you notice, there's no traffic violation associated with this. According to reports, someone called feeling that he was driving under the influence. So the officers, flagged him down. When they flagged him down, he obeyed. He made the appropriate stops. He made the appropriate this. He wasn't driving erratically. He pulled into a parking lot. He submitted to the sobriety test. He submitted to a blood test, which we don't even have the results back on. So he cooperated fully, and there's no indication he was driving poorly, just that it had been noted that someone thought that he was driving under the influence. So I believe, given those circumstances, his ties to the community, his work, everything else, a lower bond is warranted in this case with a $2,000 surety bond, if not a signature bond.
Nash, what's the history?
All right, Your Honor. The defendant has 12 cycles. The defendant's last arrest was April the 23rd, 2021 in Woodstock, Georgia for a hit and run. The defendant does appear to be on misdemeanor probation in Woodstock, Georgia for a hit and run. That disposition date was August the 16th, 2021, and the term is for 12 months. The defendant does have a prior felony conviction. It was in 2008 for possession of Schedule II controlled substance, and the defendant has misdemeanor convictions, one in 2015 for a DUI, one in 2014 for a DUI, one in 2009 for a DUI, and one in 2008 for a DUI. Nothing in addition, Your Honor.
And those are 4 convictions? Those DUIs are all convictions?
Yes, they are, Your Honor.
Good morning, Ms. Guidry.
Good morning, Your Honor.
Is this your case?
It is, Your Honor. So in this case, we're asking that you maintain the bond. In this case, on January 22nd of this year, officers received a call from the defendant's female friend who stated that he was about to drive and that he had been drinking alcohol. Obviously, she was concerned due to his criminal history. The officers got behind the suspect's car and initiated a traffic stop. The driver stopped in a parking lot, and upon exiting, he showed signs of unsteadiness while on his feet, and he had bloodshot eyes and slurred speech. The defendant performed a field sobriety test in which he performed poorly, Your Honor. We're gravely concerned for the community's safety, given that he has 4 prior convictions of DUIs, 2 within the last 10 years, making this his 3rd. He also has an open DUI from 2020 in Cartersville. Given his citation history, he has 4 DUIs citations, 2017, 15, 2009, and 2008. So we're really concerned for the community's safety, even the defendant's safety in this case, Your Honor, and he is a risk of reoffending, again, given his criminal history. So we're asking that you maintain his bond.
Anything further, Ms. Hogue?
Nothing further, Your Honor.
Given his history, I don't believe that the bond is excessive. Good luck to you, Mr. Thorman.
Thank you.
Who do we have next?
Position number 9, Mr. Fetter.
Excuse me, Judge Morrow. The
Yes.
Spanish interpreter is inquiring about her services today. Will y'all still need a Spanish interpreter for position number 10 today?
So is the interpreter only here for position 10, which I have is going to be a mental health reset? Does anyone need Madam Interpreter?
¿Hay alguien que necesite un intérprete hoy? Por favor, muestre su mano.
All right. That being no response, thank you for being here this morning. I appreciate it.
All right, you won't need me for position 10, Your Honor.
That's going to be reset.
Oh, that will be reset. Okay, well, thank you so much. I just need to get some information and I will leave soon. Thank you.
All right. tell me where we are again? I'm sorry. Position
Position number 9,
9.
Mr. Fetter.
Good morning, Mr. Federer. I'm Judge Eric Morrow. This is the state all-purpose calendar. We are conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning.
You raise your right hand for me, Mr. Federer. You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you can put your hand down. Mr. Federer, you've been charged in case 22 CR 000317G with driving under the influence of alcohol, less safe, and impeding the flow of traffic. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
Yes, Judge.
How do you plead, Mr. Federer? Guilty or not guilty?
Not guilty, Your Honor.
All right, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, Mr. Finley, and I set this bond on January 24th. It's a $5,000 good bond for the DUI and a $1,000 good bond for the impeding the flow of traffic. I don't have any present recollection of the history in this case. Ms. Nash, can you give me the history, please?
And it has one prior cycle that was July the 22nd, 2021 in Gwinnett County for a DUI. The defendant appeared to have an open case pending in Gwinnett County for a DUI and disorderly conduct. Nothing in addition, Your Honor.
So those are the 2 open cases for DUIs? Is that?
One appeared for a DUI and one is for disorderly conduct
Okay.
in Gwinnett County.
Okay, thank you. Mr. Finley?
Yes, Judge Morrow. Mr. Fetter is adamantly fighting these charges, Judge. He was born and raised in the metro Atlanta area. This is where his entire family lives. So he does have strong community ties, Judge. In recent years, Mr. Fetter has been dedicated to his future as he's tirelessly worked to complete trade school, in which he completed in 5 years, put in 10,000 hours between his work and class. As previously stated, Mr. Fetter is adamantly fighting these charges. And although he does have that other open case, he is presumed innocent in that case. Unfortunately for Mr. Fetter, he struggles with finances and has no one that's capable of helping him get out. So he simply cannot afford the bond as it currently is, Judge. That is why we are asking for a signature bond in this case, but if not inclined, then a surety bond not exceeding $1,000.
Thank you. Ms. Arnold?
Yes, Your Honor, this incident happened on January 23rd of this year at Old Alabama Road and Haynes Bridge Road. Officers responded to a vehicle stopped in the roadway. When they approached, they found the defendant passed out with the seat reclined and a strong odor of alcohol inside the vehicle. Officers tried to wake the defendant several times, but he did not respond. Emergency medical response was requested, and officers were eventually able to wake the defendant with a sternum rub. When the defendant exited the vehicle, officers observed that his eyes were bloodshot and watery, his speech was slurred, and he was unsteady on his feet. When asked how much he had to drink, he denied consuming any alcohol. The officer advised the defendant that he was going to conduct a sobriety evaluation to ensure it was safe for him to drive, and the defendant complied with this request, but he had problems following the officer's instructions. When the officer requested a breath sample, he received a positive result of 0.103 grams. The defendant was then arrested. Your Honor, we do believe that the defendant will reoffend. As pretrial has already mentioned, he has the open case from July 22nd of last year for DUI and driving on the wrong side of the road, which we have set to have arraignment on the 28th of this month. So for these reasons, Your Honor, we are requesting that the bond remain the same at the $6,000 surety.
So he made bond on the 2021 charge, Ms. Arnold.
It appears so, Your Honor. I could not see all of that information because those cases were from Gwinnett, so they're not listed in ours. But it looks like, from my understanding, he did make bond on that case.
Okay, and we're coming back. Is he on another calendar or the state all-purpose calendar for on the 28th?
Let me check, Your Honor.
I take it it's probably, well, if it's coming, it doesn't seem like you can find that, Ms. Arnold. You were gonna offer him 12 months to serve 30 days, or you offering him 12 months to serve 30 days credit for time served 16 days, is that right?
Yes, Your Honor.
So if he were to take a plea, he'd be getting out today. He's been in since January 24th on this charge. Mr. Finland, I'm gonna convert the good bonds to signature bonds through the jail. So it's 5,000 for the DUI, 1,000 for the traffic offense. I had already placed on his bond, no driving except to go to work and back. So if he's not going to work and coming back from work, then he's not to be driving. No drugs, alcohol, or weapons while out on bond. Did you get that, Mr. Finland?
Yes, I did. Thank you, Judge.
All right. Good luck to you, Mr. Feta.
Thank you, Your Honor. You got position number 12, Mr. Funfield.
And this is going to be a non-negotiated plea.
That's correct, Your Honor.
Good morning, Mr. Funfield. I'm Judge Eric Morrow. This is the state of purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning as well.
Good morning. Can you raise your right hand for me?
Yes, sir.
You swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Given that this is non-negotiated, Ms. Nash, what's the history?
The defendant appeared to have 14 cycles. Bear with me for just a moment, Your Honor. This is the defendant was last arrested September 4th, 2020 in College Park, Georgia, for theft by receiving stolen property. There was no disposition for that arrest. I'm just looking for the IC to see if there are any convictions for you, Your Honor. Do see a probation violation that was November the 16th, 2017 in Fulton County. That underlying charge was possession of a firearm by a first offender. And there was an additional probation violation in 2017. I'm trying to find that conviction for you. Okay, there was a felony conviction in 2014 in Fulton County for possession of a firearm by a convict, a firearm by a convict or felony first offender. And it was 2 counts. To receive probation for that. It was like 5 years. That was in 2014.
Okay, anything else?
And I see 1 misdemeanor conviction that was in 2012 for marijuana possession less than an ounce. You see an additional, the defendant received first offender probation in 2012 for possession of marijuana less than an ounce. Possession of marijuana with the intent to distribute. Nothing in addition, Your Honor.
Okay, thank you, Ms. Nash. Ms. Arnold?
Yes, Your Honor. The state's offer is 12 months to serve, 30 days, credit for time served, 14 days, balance probated, no further contact with Monique Daniels, Monique spelled Monique, a stay away from 4185 Shoals Lane, Shoals spelled Shoals, in South Fulton, a family violence intervention program, no drugs, alcohol, or weapons, alcohol, drug evaluation and treatment, and 40 hours of community service. Your Honor, this incident happened on April 14th, 2020 at the 4185 Shoals Lane in South Fulton. Ms. Monique Daniels advised that she was in a dispute with her living boyfriend, the defendant in this case. She advised that he pushed her multiple times in front of her 3 daughters. Ms. Daniels advised that the defendant is on drugs, and this incident was captured on her daughter's cell phone. Your Honor, I do not believe I heard pretrial mention, and she can correct me if I'm wrong, but I had it that he had an open case for criminal damage to property in the 2nd degree against the same victim, Monique Daniels, case number 20 CP 193663.
What was the date of?
That was from August 25th, 2020.
Anything further, Ms. Arnold?
I'm
Nothing further,
attempting
Your
to
Honor.
look at Odyssey, but Odyssey is moving real slow, Your Honor.
Mr. Finley?
Nothing further.
Yes, Your Honor. I had a long discussion with Mr. Funfield yesterday, and we talked about these conditions, and he and I both agreed that if the court feels the family, the FVIP and the alcohol drug treatment would be appropriate and would be beneficial to him in making his life better in the future, he is all for it. So we do not oppose those. We are asking, Your Honor, that once he completes these conditions, that the balance be suspended or not reporting. For the past 15 years, Mr. Funfield has worked at Skate Town. He's held stable employment there for 15 years now, giving skating lessons to kids. He uses the money there to support himself and his 3 young kids that are all under the age of 8. Your Honor, Mr. Funfield has not for a while had any contact, obviously, with the victim. He has no plan on, he's completely moved on from that in his life, and really adamantly stated, he's looking for his life to be on the upswing moving forward. So we are asking for the for the fees to be waived, Your Honor, so that money can be put towards him and his kids.
All right, so the only thing that you object to
It's just once the conditions are fulfilled, because we do not oppose the conditions if he can be, the balance can be suspended or not reporting, Judge.
I can go with non-reporting. Do you
Okay.
have a Ms. Arnold, an objection to he's going to be on probation for a good little while because it's going to take him at least 6 months to get through the FVIP program. You have an objection to non-reporting?
After the conditions are met,
Right, yes.
no objection, Your Honor.
Okay. And 30 days to serve, 12 months to serve, 30 days credit for time served, 15. Do you want him to stay in jail another day? You can't make
So
that.
it's to serve 30 days, Your Honor, with credit for time served is 14 days.
Right, so that'll put him at 28 days, which means they don't have to stay in custody for another day. Was that your intent?
Yes, Your Honor.
And that's your intent also, Mr. Finley?
No, Your Honor. We would ask for that to be decreased to 28 days. I'm not too sure what that one extra day would accomplish, Your Honor. So that's where we stand on that for that to be time served, the jail sentence, Your Honor.
All right. Mr. Fonfield, it's my understanding that you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I am.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Fonfield. The sentence is going to be 12 months to serve, 28 days, credit for time served, 14 days, balance probated, no further contact with Monique Daniels, stay away from the 4185 Shoals Lane address, a family violence intervention program, an alcohol drug evaluation and treatment, 40 hours of community service, and no drugs, alcohol, or weapons while on probation. I am going to waive your fees while you're on probation to help you get and stay on your feet. And as soon as you complete all of these conditions, the probation is going to go to a non-reporting status, okay?
Okay, thank you, Your Honor.
All right, good luck to you, Mr. Fonfield.
Thank you. Thank you, guys. Yeah, have a good one.
The same.
Position number 13, Mr. Anthony Foster, position number 13.
13.
And Judge Marr, this one will just be an arraignment, not bond hearing.
Good morning, Mr. Foster. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Foster, you've been charged in case 21 CR 001813A with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Foster? Guilty or not guilty?
Not guilty, Your Honor.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Okay, good luck to you, Mr. Foster.
Your position number 22, Mr. Marcus Morris.
Okay, so this is going to be a an arraignment and a bond hearing, is that correct?
That is correct, Your Honor. That is correct, Your Honor. This is Ms. Hogue.
Thank you, Ms. Hogue. Good morning, Mr. Morrison. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have the case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Morrison. You've been charged in case 19 CR 002703H with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Hogue?
Yes, I do, Your Honor.
How do you plead to this charge, Mr. Morrison? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Do you have his bond? Do you know his bond, Ms. Hogue?
Yes, it's a $2,000 cash bond.
That's correct.
What is the history, Ms. Nash?
I'm sorry, Your Honor, my system was moving a little bit slow. I apologize to the court.
Okay, that's fine.
The defendant has 34 cycles. The defendant's last arrest was April the 14th, 2021 in Athens, Clarke County, Georgia, for a probation violation. The underlying charges are not listed. Just looking through the GCIC for you. Did you see a failure to appear? That was in 2019. The underlying charge was simple battery. And I do see a probation violation. It's in 2019. That was in Madison County, Georgia. I see a misdemeanor conviction. It was in 2019 and out of Athens, Clarke County for a DUI. An additional probation violation. This is an old one that was in 2013. See a felony conviction. It was in 2013 out of Athens, Clarke County for criminal damage to property in the second degree. That was a first offender. He received first offender treatment for that one, Your Honor.
Thank you, Ms. Nash.
Okay.
Ms. Hogue?
Yes, Your Honor. Mr. Morrison is 52 years old, Your Honor. He's a Georgia native. He's lived here all his life. All of his family is here. He has cousins, aunts, everybody is here. While he did not go beyond high school for any specific degree, Your Honor, he has been a welder, a certified welder, and doing that work for over 35 years now, Your Honor. And he, like I said, he was employed before this, and because it's incarceration, he has lost his job, so he has very limited income at this time, Your Honor. What happened here, and I want to think that's very important to note here, Your Honor, is that Mr. Morrison had some court dates for which he did not receive notice for. They apparently did not send to the correct address. He was contacted by his bonding company to say you had missed court, and he turned himself in. So I think that speaks a lot that he is not trying to run from this. He is not trying to do anything of that nature, Your Honor. He turned himself in so he can get this case resolved. This case, as you also noticed, from 2017, didn't even get accused till sometime in 2019, and didn't have a lot of court dates in between. So, but the moment he found out he had a situation, he came in and turned himself in. So we do believe, given that, even though he does have a history, his history, other than some probation violations, is a 2019 simple battery and then a 2019 DUI. And then, then it's going back to 2013, which is the felony for which he got first offender treatment, which indicates he completed that and got his first offender. So, Your Honor, we do believe that given that he turned himself in this situation, the fact that he has got significant family ties here, the age of this case, and the fact that he came in and is willing to want to take care of this, that a signature bond in this case is not unwarranted.
What was his previous bond, Ms. Hogue, before it was revoked? Do you know?
I believe that
$2,000 surety bond.
$2,000 surety bond.
Yes.
Thank you. Ms. Guidry?
Yes, Your Honor. I do understand that he has a $2,000 cash bond. We are in agreement with the $2,000 surety bond. This event did occur in 2017, where he got into a physical altercation with Carrie Britt, where he admitted to getting in an altercation with Carrie Britt. Your Honor, his criminal history doesn't have any extensive batteries. He has one assault from 2013. However, he does have two failure to appears, one from 2019 and one from 2013, and he failed to appear in this case. Your Honor, we would like to note that it is up to the defendant to ensure that his address is correct with the clerk. So we are in agreement with the surety bond. And we ask that you can place a surety bond in this case, the $2,000.
Ms. Hoag, does the court have his correct address at the present time?
I'll have to verify that with him. But I will make sure that he does have the correct address. We have phone numbers for him, and we certainly will be able to reach out to him for taking care of any of his cases. And I'll verify and make sure that the court will have his correct address if it's not correct right now.
And Mr. Morrison, you do realize that it's your responsibility to keep if you move, to keep the court informed or the clerk informed of your whereabouts. You understand that?
Yes.
Okay. Ms. Hoag, if you'll do the bond modification for me. It's going to be a $2,000 signature bond through the jail. No further contact with Carrie Britt. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor. I'll get that to the court today.
Okay, thank you. And I'm here with Ms. Middlebrooks today, so all the paperwork should be coming to her, so she can get that to me.
Okay.
All right, Mr. Morrison, I'm giving you that opportunity to get out, but you have to make sure that you show up for your next court hearing. Otherwise, you'll be right back where you are. You understand?
Yes.
All right. Good luck to you, sir.
All right, thank you, Your Honor.
Position number 11, Mr. Farrell.
All right. Mr. Finley, why is this non-negotiated?
See, 1 second, Your Honor. Yes, Your Honor. This one is non-negotiated. We were just going to ask for, once Mr. Farrell does complete the community service and the theft prevention course, we were not opposing those, but just once he completes those, if he can be not reporting, Your Honor.
And you're in agreement with the 12 months to serve 30 days, credit for time served 13 days?
Yes, sir. And we would be asking for, yeah, because 13 days, we would be asking for 26 days, Your Honor. So to take off a few of those, so it would be just a time served deal. Once again, I'm not too sure what a couple days more in the Fulton County Jail would accomplish there.
All right. Good morning, Mr. Farrell. I'm Judge Eric Morrow. This is the State All-Purpose Calendar. We are conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Thank you. Good morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you. Ms. Arnold?
Yes, Your Honor. So here in this case, this happened on August 8th, 2018 at 800 West Peachtree Street Northwest in Atlanta. The defendant took a green Next bicycle, which was the property of the Georgia Tech Police Department. And when officers asked for defendant's information, he gave the false name of Matthew Farrell and a false birthday of 1/17/1970, with the defendant's birthday actually being a 1/30/68. Your Honor, the defendant he is a multi-state offender with various cycles. He has 18 cycles out of Georgia, 2 from Louisiana, 2 from Florida, 7 from Alabama, and 34 out of Tennessee. Your Honor, I will not object to Your Honor making it the 26 days for a time served, but we would ask that the balance remain probated as he is a multi-state offender, and we just want to be able to monitor what's going on, Your Honor. He has a 2020 arrest for a probation violation out of Alabama, August 21 arrest for theft by shoplifting out of Alabama as well. He has a January 28th of this year failure to appear for theft by taking as well, and criminal history, Your Honor, so we would ask that it just remain probated. So we would object to that, but we are okay with it being a time served.
Anything further, Mr. Finley?
Nothing further, Judge.
Mr. Farrell, it's my understanding that you wish to plead guilty to giving a false name, address, or birth date to law enforcement officer and theft by taking. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Farrell. The sentence will be 12 months to serve, 26 days, credit for time served, 13 days, balance probated, stay away from 800 West Peachtree Street, 40 hours of community service, and a theft prevention course. I am going to waive the fees for you while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, you'll still be on probation, but it'll be a non-reporting status, okay?
Sure.
All right, good luck to you, Mr. Farrell.
Your Honor, did anyone reach out? I mean, did anyone get in contact with Mr. Dark? I only have his client left here in courtroom too.
Okay, let's see, Ms. Lewis, did we try to contact, or have you been able to try to contact Mr. Dark?
Yes, sir. I sent him out an email and I called him and it went straight to his voicemail and I left a message. So he has not responded back to me at this time.
All right, can we reset this case? It would have to be an add-on for Thursday.
Yeah, that's correct. If you resent it to the 10th, it will have to be an add-on.
Okay.
Can you let him know that he's being reset, please?
I will let Mr. Dark know.
Okay, and this is Mr. Matthews before us?
Yes.
Good morning, Mr. Matthews. I'm Judge Eric Morrow. We have been trying to contact your attorney for representation of you this morning, and we have had no success in doing such. As therefore, we have another calendar on Thursday, so we're going to reset you for Thursday so that your counsel can be here. Okay?
Yes, but I didn't know I had one. I wasn't notified that I had a counsel.
You haven't spoken with anyone?
No, sir.
Okay. We'll try to get Mr. Someone, a conflict attorney who is supposed to be Mr. Dark, to get it, excuse me, to get in touch with you by Thursday so that they can adequately represent you. Okay.
Sir.
All right. Thank you.
Thank you, sir.
All right. So that's everybody in courtroom 2. Is that right?
That is correct. I believe the other positions are located in South Annex.
Okay. So and South. So
I do have add-on number 1, Mr. Vila, that I'm representing today.
He wasn't on my calendar. I don't see Mr. Beal on my calendar at all.
he is on the add-on calendar. We didn't get that to you all.
I didn't get the add-on calendar, Your Honor.
Okay. And what about Mr. Demetrius Walker? That's the second one on the add-on. Who's
That was Ms. Hoag's case, Your Honor.
Yeah, Your Honor, that was on my case, and he has been reset. We were not able to interview him.
all right. So Mr. Vila, do you want to reset him the next Tuesday? Mr. Finley?
Let's see here.
Judge,
Is there any sorry, go ahead, Derek.
Well, if the jail, since we still have cases to do in the South Annex, is it possible to pull him? I don't know if his offer was to resolve it today or not, but it'd be great if we could get him today.
He was, his was going to be a bond hearing. As of right now, his bond was $500. So I was going to try to get him a signature bond today.
Give me a few minutes, I'll try to go get 'em.
Okay, and hold on one second for me also. What about, is Stevie Carpenter, is that a?
That is a female judge, and she should be at the South Annex.
All right, I just want to make sure. Tobias Jackson?
I spoke with him, Judge. He is actually going to be reset to next Tuesday, the 15th.
Reset to the 15th, thank you. 16 is, looks like it's a female. 17, Maynard Lattimore. Who represents Mr. Lattimore?
I represent Mr. Lattimore, Your Honor. I called back and I was told that he was returned, so we'll just have to reset him.
Reset till next Tuesday?
Yeah, reset to next Tuesday.
All right. Position 25, that's the female. Position 26, Torrance Roebuck.
Yes, Your Honor, Mr. Robarts has been reset to next Tuesday because he has a mental health court hearing on this Thursday.
Okay. 27, that's female. 28, female. 9, female. 32, Marquise Watson.
Position 25, Ms. Pristel. She elected not to join the court today. She's actually a medical over here at the jail.
Okay, and so is that reset till next Tuesday?
And actually, Judge, that's one that we'll need to do a breakout on for her and Ms. Carpenter at the appropriate time.
Okay, so you want to, even though she's not here, you want to do a breakout on her?
Yes, to discuss.
Okay. And let's see, finally, Marquise Watson, position 32.
Yeah, he's reset to next Tuesday as well, Your Honor.
Okay. All right, thank you. So we're looking for a position on the add-on calendar, Mr. Vila, is that right?
That's correct, Judge.
He's en route, Your Honor. He's en route.
Okay, thank you. So we'll go on to, until he gets there, we'll go on with this, so we can get the South Annex on. We'll start with the South Annex.
Let me call the South Annex and tell them no.
Okay. All right, thank you.
Thank you.
Let's see.
In the meantime, Judge, if y'all want to go in that breakout room at this time? Into South Annex, log on.
Okay, and before we do that, Quintavious Warren, he's a probation revocation. What were we doing with him?
Yes, Your Honor, that is mine. We are, and Mr. Warren, they were asking to revoke his balance, Your Honor, and we were asking for him to continue on probation.
So he's not, courtroom 2 is, probation revocation, Quintavious Warren. All right, so Ms. Lewis.
Yes, sir.
All right, when you put us in the breakout room, will you also inquire with courtroom 2, since they don't seem to be responding right now?
He said he had left to go and get the individuals.
Right. So if we're in the breakout room, would you inquire of him about the probation revocation, position 2, Mr. Warren?
Yes, I can do that.
Okay. So if you can go ahead, if you'll go ahead and put us in the breakout room, who all needs to go in the breakout room?
That's Natasha Prestel, correct?
There are 2 of them, I believe. I'm not sure which 2.
Position 4, right. Stevie Carpenter and Natasha Prestel. Position 4 and position 25.
Okay, and who all needs to go in the breakout room with Mr. Howard?
Myself, Hopkins, Alexandria, and the PDs who need to go in.
Right. Mr.
Okay.
Finley,
Myself and
Mr.
Mr. Finley, Judge.
that's
He's
you.
not.
Who else?
Just myself and Mr. Finley.
Okay, all right. So, Ms. Lewis, whenever you're ready.
Deputy in courtroom 2, can you hear me? Deputy in courtroom 2.
Go ahead.
The judge wanted to ask you about, inquire about.
Give me 1 second, give me 1 second. The
Okay.
alarm is going off. Go ahead.
The judge want to know about the other probationer, Mr. Warren, who's on the probation revocation calendar.
Oh, he was reset, I believe. You might want to talk to Finley. I think that was Finley's client. To the
He
Finley,
said on the probation revocation calendar.
yeah, they reset him. That wasn't me.
Okay, I'll let the judge know that's what they had announcement.
Okay.
But is he present? I mean,
No, he was never present. They sent us a notification and email, tell us not to bring him.
okay, I'll let the judge know when they come out from the breakout room.
Appreciative.
All right, thank you. They'll be back. That's why they're in a breakout room right now. Who that we have right there?
Thank you for telling me. I was like, what's going on?
No, they're in a breakout room. Who's that right there?
This is Mr. Vila Gabriel.
Okay, he's the one on the add-on. Okay. All right,
Thank you.
you're welcome. Judge Morrow,
Yes.
regarding the other probationer, they was said that, it said that he was being reset. I don't, he told me to speak to Mr. Finley about it.
All right. Did you hear that, Mr. Finley?
I was just getting back into the room. Could you repeat that, Your Honor?
Apparently, the probation, they thought he was being reset.
I know I did not at least send anything saying that he would be reset. So that's news to me, Your Honor.
Well, apparently he's not here, so
Okay.
when do you want to reset him?
Could he be?
Add on Thursday?
Yes. Yes, please, Judge.
Okay. All right, is that fine with you, Officer Middleton?
Yes, sir, that's fine.
Okay, all right. Thank you.
May I be excused?
Yes, have a good afternoon. I'll be here if you want to get those that paperwork signed.
Okay, thank you so much.
Okay. So who do we have in courtroom 2 now? Is this Mr. Vila?
Yes.
So this is going to be arraignment and a bond hearing.
That's correct.
Yes, Your Honor.
Good morning, Mr. Vila. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can put your hand down. Mr. Vila, you've been charged in case 22 CR 0000237E with criminal trespass. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
Yes, I do, Judge.
How do you plead, Mr. Vila? Guilty or not guilty?
I don't know. My lawyer speak on my behalf.
Mr. Finley, it's my understanding that he was going to plead not guilty today. Is that correct?
That is correct, Your Honor. Yes, Mr. Vila, that's what we agreed upon, to plead not guilty today, and then I would argue bond for you.
Then not guilty.
Okay, we'll record your not guilty plea, and your case will be returned to the division judge. You'll get further notification. Do we know who was there that day? Y'all hold on for me just a second. It's January 21st. If it was me, I don't know how I missed it. January 21st? Right. Okay, fine. Judge Williams set a $500 good bond on January 21st on this matter. Mr. Finley?
Yes, Your Honor. Mr. Vila is 30 years old. Judge, leading up to his arrest, he was working at Brighter Image Painting as a painter. There he was helping provide for himself and his dad. Mr. Vila has been in jail since January 18th, which means he's now been incarcerated for 21 days, during which time his bond has been set at, as you mentioned, Judge, at $500 good bond. So he could go through a bonding company and it would be $50 to $75 with fees. So that is the amount that has been keeping him in for nearly a month now. As we know, Judge, bond is not meant to be punishment, but rather to ensure his return to court. But for the fact he's been in there for 21 days for a bond, that'd be $50 to $75. With fees, it does seem to be punishment, and it seems to be punishment for being poor and struggling with finances. So that is why, Your Honor, we are asking for a signature bond in this case.
Adrian?
Yes, Your Honor, we're asking that you maintain that bond. In this case, on January 17th of this year, officers spoke to the owner of 3131 Dale Drive Northeast, who stated that she had a house for sale and that nobody was to be at the location. She said that she observed the defendant on her camera system to enter the house around 9:30 without her permission. When officers received the code and entered the house, they found the defendant sitting on a table watching TV. Your Honor, the defendant has an extensive criminal history. He has 27 arrests in California. His most recent was for a burglary, August 1st, 2020, cruelty to animals, and vandalism. He also has an open warrant out of Los Angeles for that vandalism. He has criminal history out of Illinois for a larceny with no disposition in 2014. And he has criminal history here with 7 arrests, Your Honor. Most of his convictions were out of California. They include cruelty to child, 2017, disorderly conduct from 2016, non-commercial dwelling, 2017, and other convictions, Your Honor. So given his criminal history and that he's a multi-state offender, he is a flight risk and he is a risk of reoffending. So that's why we ask that you maintain that bond. And to be frank, Your Honor, this bond is very low given his criminal history. So we ask that you maintain that bond.
Do you have a place to stay, Mr. Finley?
Yes, he does, Your Honor. He's going to stay with his dad. He did not have the address for me off the top of his head, but he said he would make sure to get back with that address. And I really emphasized, because I know how much you stress that, Your Honor, that he needs to have an address on file.
All right. It's going to be a $2,000 signature bond through the jail. Stay away. Do you have his previous bond, Mr. Finley?
Yes, well, yes, his
Do I need to say it?
$500 surety bond.
Right, it's gonna be a $2,000, right, it's gonna be a $2,000 SOB through the jail. He's to stay away from the 3100 Peachtree Drive and the 600 Greenview Avenue addresses, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Vila.
Thank you, Your Honor.
Thank you, Judge.
So I think we're still waiting on the South Annex.
That is correct, Judge. I've been trying to reach them, but nobody's picking up the phone.
All right, so thank you, courtroom two. We appreciate it today.
Oh, you're welcome.
All
So
right,
we
see you
completed
later.
here in courtroom two, correct?
Yes, I believe so.
That's why, is there a way you can call the South Annex to ask them to log on for me?
Okay, no problem.
Thank you.
Thank you. Okay, we'll be in recess until South Annex comes on.
Excuse me, Judge Judge Morrow.
Yes.
Yeah, I just spoke with South Annex. She said she's doing another calendar. If you can give her anywhere less than 10 minutes.
Okay, thank you. We appreciate it.
All right, you're welcome, no problem.
Can someone let South Annex in, please? They're in the waiting room. Let South Annex in.
They just got on.
Thank you.
Their name just popped up. They're getting on now.
Sorry, Your Honor, for being
No
late.
problem. No worries.
I have before you position number 2, Miss Blackwell.
Hello. Hello.
Hi, Ms. Blackwell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. You agree to have your case heard by video? We're doing this. We're doing this. We're doing this over.
You need to be quiet and
No,
listen.
some of my hearing is lost.
Okay. We're doing this by video. Do you agree to have your case heard by video?
Yes, okay.
Okay. Can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Let's see. What's the issue? This is non-negotiated, Mr. Findlay?
Yes, Your Honor. That's I stand corrected. I'm sorry. This should be a negotiated plea, Your Honor.
Okay. Ms. Arnold?
Yes, Your Honor. This incident happened on December 9th, 2020 at 496 Rankin Street Northeast in Atlanta. The defendant was found sleeping on the porch of Keith DeVries, spelled DeVries, and refused to leave his property. When the officers arrived and asked if the defendant needed medical attention, she told them, no, just take me to jail. The officer advised that she leave, and the defendant began to walk away, but insisted on being taken to jail. The officer made several calls to local shelters to take the defendant in, but they all refused, unfortunately. And the defendant continued to go back on Mr. DeVries' property after the officer asked her to leave several times, and after that, she was arrested. Your Honor, the state's offer is 12 months probation with credit for time served 10 days. We're also asking that the conditions be that there be a MHET, a stay away from 496 Rankin Street Northeast in Atlanta, no drugs, alcohol, or weapons, and the balance be probated.
Yes, Your Honor. I do apologize that this should have been a negotiated plea. So we do agree with the state's recommendation, Your Honor, and would just ask for that after the MHET, that it could be non-reporting, and also that her fees could be waived, Judge.
Does she have somewhere to stay?
She said she's going to have somewhere to stay. She did not have an address for me, Judge. I did really stress to her that it'd be really helpful if I had an address. She stated she did not have one, but would get back to the court with an address. She did assure me, but I made sure to really stress that to Ms. Blackwell.
Your client has her hand up, Mr. Finley.
Yes, Ms. Blackwell.
I gave you 24, 22 Crescent Circle in Decatur, Alabama. That's a mailing address. They'll let me stay there 1 or 2 days until I can see if I can get in the Salvation Army. So I can stay in the Salvation Army. That's what I'm saying. I got a list right here that I can homeless shelters I can get in right here. But I haven't had it. I didn't bring them with me yesterday because I had let you see them. Can you see them?
Okay, thank you, thank you. Yes, Ms. Blackwell, thank you.
Yeah.
Okay, hold on for me for a moment, sir. Mr. Howard?
Yes, sir.
May I see you and Mr. Finley, Ms. Arnold,
Sure.
in a breakout room, please?
Okay, I'll get them in there.
Okay, thank you.
Could you also put Mr. Hopkins in the breakout room? Thank you.
Thank you.
Oh, yes, I didn't see you there, Mr. Hopkins.
That's all right. I lurk in the shadows.
Oh, excuse me.
Okay,
Your Honor.
hold on.
And I work with Carlene, the public defender downtown also. Can I use some of that spray?
No, ma'am.
Oh, I sure did keep my bottom of my shoes sprayed off. In or out? Or what about with a night, a white paper towel? Can use that Clorox spray. You should wear my hands up. You know, it hurt when it's your body. I have ankle support. Yeah, the decoration on my, yeah, I like the decoration on my toilet paper. Yeah, tomorrow's another day. I'm thirsty and bring on the and you think it's hard for me, but the more you do it, the easier it gets. Man. So you get it in the back. Y'all should have with the man. Except I do what I do. Why you gonna dress in here out of my head? I will bet I need to add it on your table.
Oh, this one right here?
Yeah.
It's all right.
Let me see. Where is it?
It's okay if I bring this to her? Just, no, just leave it right there. Who's this? She's asking for it. That's her? In your chair. Is that you? Is
Yes,
that her?
yes. Thank you.
I don't need to move. You stay right there.
Okay. Yeah.
I must have sat in her seat
Yeah.
or something because it was right here. No problem. I'm sorry.
Okay. Yeah. And the gym is, well, the second one. Right here. Like, I got a silver window in the back. Yeah. With a C on it. With a C. Anybody need a homeless? I got some, like, first aid, first, Atlanta Mission, Crossroads, City Refuge, Central Outreach, First Presbyterian, the Promise Center, Lost and Found, Chris, it's Covenant House of Georgia. Anybody need any of these? Anybody? You think they make a copy? You think you make a copy of this? She said she needed it.
No, ma'am, I don't have access to make a copy of that.
Yeah, we're giving you the one beside mental health. Is that when you first come in? If I can make a copy of it. You got an ink pen, huh? Can we use your ink pen? Hey, you wanna look over my, is that all right, she look over there?
Yes, that's
And
fine.
she named, cause people been abused and stuff.
Officer Melton?
Oh, sorry. Yes, sir.
I'm going to have Mr. Finley and Ms. Howard speak with Ms. Blackwell by phone. Can you give them the number that, or
361. Oh, God. 371-22.
You need to take about 2 weeks.
Young lady, relax.
You excellent work.
Toad? While Mr. Finley, I want to.
Have a seat right here, please.
Okay.
I'm sorry. Okay, sit down. Oh, please. I'm sorry.
Okay, leave it on, please.
No, speaking.
Thank you.
No, not yet. I'm sorry. I will call you by the way. Okay, thank you. First appearance, Milton. Okay, thank you. Here.
Okay, yeah, put it back up.
Mr. Howard.
Yes, Judge.
I think I feel more comfortable if you had a social worker talk to her. Would that be
Okay.
possible? All right.
I can get one of them. I can get one of them on. Yeah. If you,
Okay,
I can call one of them to get on the line now, Judge.
okay. And if you'll do that for me, I think that, that might be of assistance to you all also.
Okay,
Is
sure.
it possible if they can come down here?
I mean, while we have her there, I prefer that we
Okay.
make contact now.
Okay,
Because with staffing at South Annex, sometimes it's difficult to get in and out, you know.
okay. You want to go to the next one, Your Honor?
Yes, please.
Just put this one. Position number 4, Ms. Stevie Carpenter.
And Deputy Milton, yes, I've already explained to Ms. Carpenter what's going on. She's aware of what the plan is, so you can go to the next person on her.
Okay, have a seat over there for me. Next, we have, position 16, Ms. Johnson.
Get Ms. Johnson's bond, please.
Sit right at this.
Okay, well, he's back with us. Good morning, Ms. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help with virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yeah, you can put your hand down. Thank you. Ms. Johnson, you've been charged in case 21 CR 003894A with 2 counts of theft by taking. Each of the charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
Yes, Judge.
How do you plead to these charges, Ms. Johnson? Guilty or not guilty? South Annex, you're mute.
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Mr. Finley, I have down that I set this bond on July 28th of last year in the amount of $1,500 per charge. So it's a $3,000 signature bond through the jail. Why are we back here?
She was arrested, Your Honor, on a burglary charge. So was that, I didn't see that bond was, or I guess the signature bond. Okay, I guess it would be revoked. So then we will ask for a reduction of that bond, Your Honor.
Did she get a bond on the burglary allegation?
One second. Yes, Your Honor, she did. 1 second, let me pull that up if you don't mind.
It was a $5,000 church fund.
Yeah.
Ms.
Put the phone to your ear.
Arnold?
Yes, Your Honor, this incident happened on July 22nd and 27th of 2021 at the Renaissance Lofts located at 120 Ralph McGill Boulevard, North in Atlanta. On July 27th, the concierge showed officers a video of the defendant leaving with packages belonging to victims Carlistra Nicome, first name spelled Karlystra, Nicome spelled Nicome, and Jeffrey Cone, Jeffrey Jeffrey, last name spelled traditionally. Your Honor, we would request that the bond.
Hold on. South Annex, could you please mute while we?
Yeah, I got. Crossroads.
Thank you. I
I'm
apologize.
sorry, I didn't hear the victims' names.
Okay. Thank you, Ms. Howard. Can you go back to the victims' names, the alleged victims' names, Ms. Arnold?
Yes, Your Honor. So the first victim is Carlistra Nacombe, spelled Karlystra, last name Nicome, and Jeffrey Cone. Jeffrey spelled Jeffrey. Cone is spelled traditionally. Your Honor, as you already mentioned, you had originally issued a $3,000 signature bond, $1,500 signature for both counts of the theft by takings. The state is requesting, I did not see where it was converted, but the state would be requesting that that be a surety bond, $1,500 for each count. We do believe that the defendant will reoffend based on the fact that she's brought back here today for the burglary charge with the case number 22CP206171. Thank you, Your Honor.
All right, and I'm being told by Ms. Lewis that that this was an FTA, that she was on the Apollo calendar and did not appear for the Apollo calendar, and a bench warrant was issued. And that's why she is in custody. She's on that bench warrant. All right, Ms. Finley?
Yes, Your Honor. While I do recognize Ms. Johnson's recent arrest, she is presumed innocent in that case, Your Honor. We are asking for a bond reduction. We're asking for $500 for each charge, which would be $1,000 total surety bond.
Anything further, Ms. Arnold?
Nothing further, Your Honor.
All right, so it'll be a $500 surety bond on each charge, which makes it a total of $1,000 surety bond. No further contact with Mr. Cone and Ms. Nicone. Stay away from the 120 Ralph Hill Boulevard, apartment 156 address. No drugs, alcohol, or weapons while out on bond. Did you get all that, Mr. Finley? You're on mute.
Yes, Judge Morrow. Just want to clarify. So it was 500. It was the 500 for each surety.
That's what you requested, right?
Yes, yes, it is. Just want to make sure. Thank you, sir.
Okay. All right. Good luck to you, Ms. Johnson. Thank you.
Ms. Purcell is at the, Ms. Skipper, position number 27.
It seems like it's a problem somewhere. And she didn't wipe this phone off. I got a problem with that. I don't know, I'm asking her to wipe the ear part and the mouth part off.
Your Honor, I'm gonna put on mute, okay?
I ain't got time
Well,
for
I'm gonna have to speak with her first.
Okay,
because I
go ahead.
haven't been back. Yeah, but I haven't been able to.
This is gonna be a
Yes, I
non-negotiated plea. Good morning, Ms. Skipper. I'm Judge Eric.
And,
This is the state office calendar.
yeah, wipe that off, man. That's all.
Okay.
Thank you.
Let's see.
I was going.
I'm sorry, I can't get through this.
Yeah. And Your Honor, I need a moment. I had announced with Ms. Skipper, I do need a quick, like 2 or 3 minute breakout room moment with her, if that would maybe help while we resolve the other issues.
Okay. Can we put them in a breakout room?
Yes. No, I went to rehab, but I'm sure that, but see, in the morning, you can get in Salvation Army, but you gotta be there by 8 o'clock in the morning. That's why I said 1 or 2 more days.
Yes.
What last name did you say? What's your name? Skipper.
Skipper?
Yeah.
Okay, what's your name?
That looks like that's not, well, you can clear that up when you get in the breakout room, Ms. Hook. All right, we'll be in recess until they come back. Sorry, everybody. Okay, so where are we here?
We're ready to proceed, non-negotiated right now with Ms. Skipper. Is that, I assume, who's we're working with, right?
Yes, ma'am.
So this is Ms. Skipper before me?
Yes.
Okay, good. Good morning, Ms. Skipper. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. What is the issue with the non-negotiated, Ms. Hogue?
The biggest issue, Your Honor, and we understand the state's position, is that they want the $300 fine, which is mandatory. We understand that. She is financially strapped, Your Honor. She is 23 years old. She has a high school degree, but no college. She was working in the smoothie place, but as you know, with the jobs, she no longer is working right now, and she is 3 months pregnant. So what we're hoping for is the sentence is asking for her to do a defensive driving class as well as a $300 fine. Since we can't convert the $300 fine to community service because it's mandatory, we're hoping maybe to then, instead of the defensive driving course, make that some additional community service instead. That's the only sticking point right now, and mainly waiving fees, because like I said, she's just financially strapped. Her mom's going to try and help her out, but she doesn't have a job, so she has no real income. So we're just trying to work the best thing for her financially right now.
It's my understanding that I can suspend the $300 fine if I choose.
Oh, I thought you couldn't, but if you can, then we'll go with that instead.
Your Honor, we're fine with the fine being suspended,
Actually, we're not fine with that, Your Honor. We're not allowed by law to go ahead and suspend a fine on a DUI. It says it shall not be suspended.
This is not a DUI.
Okay, if it's not a DUI, then we have no objection to that.
Okay, thank you, Mr. Huff.
I wasn't sure if you could suspend the fine, Your Honor, but that'd be fine.
All right, so if I suspend the fine, then all the other terms are agreeable.
Yes, Your Honor.
All right. And I see that you have 40 hours of community service down here, but it's 40 hours total. It's not 80 hours, or what was
It's 40 hours total. That's correct.
40 hours total. Okay, so I'm going to give her the 40 hours for the hit and run, and for the failure to maintain lane, it's just going to be 12 months to serve, 28 days credit for time served, 14 days balance suspended. Is that agreeable?
Yes, it is, Your Honor.
That's
She'll
agreeable.
she'll be on probation for the other until she completes the terms. All right, anything further, Ms. Guidry?
Nothing further, Your Honor.
All right. Ms. Skipper, it's my understanding that you wish to plead guilty to hit and run and failure to maintain lane. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Ms. Skipper, for the hit and run. It's 12 months to serve, 28 days, credit for time served, 14 days, balance probated, a defensive driving course, 40 hours of community service, $300 fine, which I'm going to suspend, and no alcohol, drugs, or weapons while on probation. For the failure to maintain lane, 12 months to serve, 28 days, credit for time served, 14 days, balance suspended. When you complete the terms of the probation, the defensive driving course, and the 40 hours of community service, then the probation will terminate. I am going to waive probation fees while you're on probation to help you get and stay on your feet. Did I miss anything, anyone?
Your Honor, I just want to make it clear with that fine. I looked at the code one more time. It says that upon conviction, the fine, $300 and not more than 1,000, shall not be subject to suspension, stay, or probation. Just wanted to make you aware of that.
Okay. Well, I'm glad that you did. I've been suspending fines in this regard. So instead of the 40 hours of community, her problem is that she can't pay the $300. Is that right, Ms. Hogue?
That's correct, Your Honor. It will, that and the driving course and all that combined, you know, the 300 turns into about 500, you know, once they finish with the surcharges and everything. And then she's got the driving course on top of that. That just puts a financial stress.
All right. So if I don't require the defensive driving course or the 40 hours of community service, would that put her in a better position to pay the $300 fine?
Yes, it would, Your Honor.
All right, so that's what I'll do. 12 months to serve, 28 days, credit for time served, 14 days, balance probated, a $300 fine, and no alcohol, drugs, or weapons while on probation. And when the fine is paid, Ms. Skipper, then the probation will be suspended. Okay?
Okay.
All right. Good luck to you, Ms. Skipper.
Thank you, Your Honor.
Thank you.
Next, we have Ms. Stivers, position 28.
Okay. So how much time is on that?
Your Honor, Ms. Stivers is a jail jury and we don't need a bond hearing.
Okay, so this will just be an arraignment.
Okay, can we get around the concur?
Yeah, just.
Okay. Good morning, Ms. Stivers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Put your hand down, Ms. Stivers. You've been
I
charged
will stay here and don't leave.
You've been charged in case 21 CR 0049992F with theft by taking. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Hogue?
Yes, we do, Your Honor.
Ms. Stubbs, how do you plead to this charge, guilty or not guilty?
He's talking to you. I thought I was supposed to have this put on.
Your Honor, it's what we talked, you're pleading not guilty.
Not guilty. What you talking about?
You're pleading not guilty today, Ms. Stivers, is that correct?
Yes, sir.
All right, I'll record your not guilty plea. Your case will be charged to the division judge. You will get notification of your next hearing. Good luck, ma'am.
Position 29, Miss Gloria Thomas.
So if I get out today, I'll be coming back to jail.
Good morning, Ms. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case?
All I got is one uniform, one bra. I ain't even got.
For me.
I'm sitting down.
Swear affirm the testimony.
I will never get to go out. I take one shower since I've been.
I do.
One.
Thank you, ma'am. You can put your hand down.
Yeah.
Ms. Thomas, you've been charged in case 21 CR 000661E with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Hogue?
She's on mute.
Oh, sorry. Go ahead, sis.
Yes, we do, Your Honor.
Okay. How do you plead, Ms. Thomas, guilty or not guilty?
Or
Not guilty.
Or you're not guilty plea, and your case will be returned to the division judge.
No, I don't want to.
Your Honor, we would like to be heard on bond.
Okay. Let's see.
Okay. I mean, what we should.
Next, please. Ms. Nash, what's the history?
Sorry, Your Honor. The defendant has 11 cycles. The defendant's last arrest was November the 26th, 2019 in Henry County, Georgia, for a failure to appear. The underlying charge was driving while license suspended or revoked. The defendant did receive first offender treatment in 2012 out of DeKalb County for theft by taking. And the defendant has a felony conviction that was in 2007 out of Douglas County of felony theft by taking. Nothing in addition, Your Honor.
All right, Ms. Hogue, this was initially a $10,000 signature bond through pretrial. What were the problems?
Your Honor, yeah, and we'd like to address two cases here at the same time, Your Honor, bond on two cases, and I'll explain. Your Honor, yes, the case before you is, let me put it out here, 21 CR 000661E. And for which Ms. Thomas received a signature bond at that time. Ms. Thomas did get charged in August of this year, pardon me, not this year. I still haven't switched my years, Your Honor, I apologize. In August of 2021, with disrupting a public safety, I believe, school bus situation and a possible simple battery here. At that time, she wasn't there. I guess warrants were issued or whatever, and this is what has happened. At the time, her son was, supposed to be taking the bus. There was some issue about him getting on the bus. After this time, her son continues going to that school. She's been continuing with the social work and everything there. And then when she, I'm gonna have to back up here because it is confusing, so we want to make sure we cover everything. I will apologize. So I'm going to start from the very beginning, Your Honor, just to give you a full history here. Ms. Thomas is 30 years old, Your Honor. At 16, she had a troubled childhood. And 16, she became an emancipated minor. Okay. Even despite that, she graduated high school, Douglas County. She got 2 years of college in before she became pregnant in 2010, had her son, and dropped out. She had jobs after that, including, 2-3 years with Delta, washing airplanes, administrative assistant and everything else. In the early of 2021, she became pregnant and was not able to work at that time. And that is when she also picked up the charge here. She was diagnosed as bipolar. When she became pregnant in 2021 of January, February timeframe, she did go off her medication for concern of her unborn child. That is the issue of this 21 CR 000661E case. Okay. At the time, she was concerned about how the alleged victim in this case was interacting with her son. Okay. After that, she did, in fact, she got her signature bond. After that, in fact, she did reach out for advocacy. She's also reached out for help from social workers and everything else for her situation of being unemployed and having a child. She and the alleged victim in this case did work out with advocacy regarding whatever issues she had with the child and how he was interacting with him. Okay, but then in August is when she did pick up this charge relating to the buses. She was not arrested. She was not aware she had warrants. After she had her child, she was concerned that she wanted to see what the bond was because the victim in this case, Your Honor, is also the father of the child. So she was trying to interact and find out exactly what she could do to the bond so that he could actually have, you know, interaction, see the child and everything else. So when she called the court, they informed her of these warrants on this case. So she made arrangements. She, made arrangements for taking care of her child and her son and turned herself in. Right now, she is in line. She's had, like I said, financial problems. She is under the, I think she's told me, under the McKinney-Veneto Act. They've found her housing now that is only open for a while. So if she doesn't get that space soon, she could lose it for her and her son. So she turned herself in, Your Honor. She turned herself in to take care of those warrants, even though she didn't even know about them. And from the time she got the interaction with the school in August till she found about these warrants, she's been at that school working with the social workers. Her son's been continuing to be on the buses. They all told her, only thing they told her was under investigation. She had no idea she had warrants. So she came forward to take care of these warrants herself directly, Your Honor. And like I said, in fact, now with this new potential housing through our house project, her son is now going to even be going to a different school, won't have to even be taking the bus. Okay, Your Honor. So right now what we're here is saying she turned herself in. They revoked her signature bond, as you know, as typically happens when they get arrested or come in for warrants, and now changed it to a $10,000 surety bond and then gave her $2,000 surety bonds on the case from August. What we're seeking here, Your Honor, is to change those all to signature bonds again, given her financial situation, the fact that she turned herself in, the fact that she, in all these situations, have always reached out for help, has followed the court orders. She was looking to follow the court orders when she was seeking to find out about modifying the bond so that, Sharif could come in and see his son. So, Your Honor, what we're seeking right now is to have her bonds on both cases switched to signature bonds at this time.
Okay, so I've been told that the other case that you're speaking of, Ms. Hogue, is on the SAP calendar for Thursday. And I don't know if the state is prepared to go forward with that case today. I certainly don't have that case before.
No, Your Honor, we don't have that case. But we can go forward on it on Thursday, not today.
All right. Ms. Hogue, given that, would you rather this all be reset for Thursday?
If you're, because what we're trying to address in all these cases is bond, would it be better for that? And then we can address bond on both cases on that day?
That's fine with me if it's fine with you. I can, since she's already on for Thursday, it's not going to be me, but since she's already.
Well, I'd then rather try and address the bond here today for the one case in front of us today.
Okay, so give me a second. Ms. Hogue, I would feel more comfortable because Judge Law was the one who issued the present bond that we're here on. She is going to be the judge on Thursday. I'd rather she hear the bond that she had and do these both at one time. Okay.
Okay, Your Honor.
All right. And that's, if I had issued it, then it would be a different story. But since she did and she's going to be here and you have to be back on Thursday anyway, I'll let you address the bond then. But you can also let her know that this case has already been arraigned. Okay.
Okay. Thank you, Your Honor.
All right.
Thank you, Your Honor.
Good luck to you, Ms. Thomas.
Ms. Blackwell, this way, please.
Take this.
No, leave that alone. Have a seat, please. Thank you.
Okay, where are we, Mr. Finley?
Yes, Your Honor. Mr. Howard has an announcement. He just let me know on this case.
Mr. Howard, tell me again the position.
Yes, Ms. Blackwell is position number 2, Judge.
Okay, thank you.
Not sure. It's here.
Mr. Howard, are you there?
I just talked to him about 20 seconds ago. Can I give him a quick call?
Yes, that's fine.
All right. Thanks, Judge.
Okay, it's not speaking. Okay. Okay, give me as soon as I can, I should- I'm gonna bring all the list around that number. Okay?
All right, Judge Mara, Mr. Howard is on the
Yes.
Zoom.
Judge, is this Ms. Blackwell? Judge, we're gonna ask that this be reset, maybe a couple of weeks. We're not gonna be able to do anything with it today. We're able to determine, it looks like she has some other matters holding her, so she wouldn't be released today. I'm not comfortable that she's able to do anything with it today. So we're gonna ask that it be reset a couple of weeks, and our social worker is gonna continue to follow up with her and to talk with the Superior Court social worker to see if there's something that can be done to handle these at the same time. Ms. Blackwell indicated that she wanted to try to handle both of these together. We don't know if the timeline will allow us to do that, but we definitely want to look a little further into it and some of the concerns she relayed about, what's happening at the jail. So we'll talk more about that with her as well.
Okay, so
Excuse me, Your Honor. I need mental health and physical. I haven't had it in 10 months. And the stuff you're supposed to, and the things you're supposed to get, what I got on, this is all I got. I'm sitting on a plastic mat.
Ms. Blackwell, we're gonna have
I'm mentally
someone's gonna be there to address your concerns, okay? So
yeah, okay. They say that all the time. That's blowing smoke. And they do the same thing. Mental health. I ain't had my mental health medicine since I've been here. I've been
okay,
trying to.
Ms. Blackwell.
Ms. Blackwell.
How you supposed to get an independent right now?
Your Honor,
Ms. Blackwell.
Okay,
bye.
thank you. We'll reset this. Tell me what you want.
222, Judge. 222, yes.
All right, thank you. Yeah, 222.
Yes.
All right, thank you, Mr. Howard, Mr. Berlin, I appreciate it.
Thank you, Judge.
Judge, can I have an update? I'll let you know about Mr. Dark. He did get in touch with me. He said that he can appear for Thursday's SAP for his client. So I converted that information to him, what needs to take place on Thursday.
All right, thank you. Is that everyone? Are we waiting on anyone?
I don't believe so.
Okay, well, it appears that South Annex has left us, so if you all, I'm with Ms. Middlebrooks. If you all will make sure that to get your paperwork into her as promptly as you can. And excuse me, and as soon as she is ready, we'll go over the calendar.
Position number 1, reset SAP February 17th. Position number 2, reset SAP February 22nd. Position number 3, reset SAP February 15th. Position number 4 is a bond modification order. Position number 5, reset SAP February 15th. Position number 6 was arraigned, reset further notice. He received a bond modification for $2,500 sign on bond through the jail. Position number 7, reset SAP February 15th. Position number 8 was arraigned, reset jail jury. Position number 9 was arraigned, reset further notice. He received a $6,000 sign-on bond through the jail bond modification. Position number 10, reset SAP March 3rd. Position 11 was a plea. Position 12 was a plea. Position 13 was arraigned, reset jail jury. Position 14 was arraigned, reset jail jury. Position 15, reset SAP February 15th. Position 16 was arraigned, reset jail jury. Received a $1,000 good bond modification. Position 17, reset SAP February 15th. Position 18, reset SAP February 15th. Position 19 took a plea on February 1st. Position 20, reset SAP February 10th. Position 21, reset SAP February 10th. Position 22 was arraigned, reset further notice. There's a $2,000 sign-on bond through the jail bond modification. Position 23, reset SAP February 17th. Position 24 was no pros. Position 25 is a bond modification order. Position 26, reset SAP February 15th. Position 27 was a plea. Position 28 was arraigned, reset jail jury. Position 29 was arraigned, reset. I put there reset SAP for February 10th.
That is correct, Natalia.
Okay.
For the other case.
Yes. Position 30 was arraigned, reset jail jury. Position 31, reset SAP February 10th. Position 32, reset SAP February 15th. Position 33, reset SAP February 17th. On the add-on calendar, position number 1 was arraigned, reset further notice. He received a $2,000 sign-on bond through the jail. Position number 2, reset SAP February 10th. And the probation calendar, position 1 is to continue on probation. Position 2, reset SAP February 10th.
Okay, any questions, concerns?
No concerns, Judge, but I do have an update on 25 that I need to share with the state. So, and Your Honor, just an amendment to the order. So if Mr. Hopkins, Ms. Arnold, and myself could be putting a quick breakout so that I can explain that.
All right.
Okay.
And whoever's not going, I guess y'all have a good rest of the day.
And I am Ms. Guidry.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Judge Morrow.
Honor.